If you're a green card holder right now, or if you're waiting for approval, or if you care about someone who holds permanent residence in the United States, I know the headlines can feel heavy. And yes, there are real situations happening in February 2026 that are affecting immigration processing and creating uncertainty for many families. My goal today isn't to create fear, it's to bring clarity. When you understand what's actually happening, who it affects, and what the rules really say, you feel more prepared, more confident, and more in control of your journey. Hi, and thank you for trusting me to walk with you through these important updates. Every day, policies shift, announcements come out, processing timelines change, and there are details that can sometimes make a big difference. In this episode, we're going to talk about the truth behind green card security in 2026, what's happening right now with immigrant visa processing, how green card holders can lose their status, and what all of this really means for people living in the United States, applying from abroad, and planning their futures. And as always, this is not legal advice. I'm not a government official or an attorney. I'm simply here to help you understand information in a simple, calm, and supportive way so you don't feel lost or overwhelmed. A lot of people are seeing headlines right now that say things like green card ban, 30 days, status lost, and immediately their hearts start racing. I understand that reaction. When you've worked so hard to build your life in the United States, when you've invested years of paperwork, interviews, waiting, and hope, any news that sounds threatening feels personal and scary. So let me start by being very clear about what is actually happening right now versus what is not happening. There is no policy in February 2026 that requires current green card holders living in the United States to lose their status in 30 days. That is not happening. If you are a lawful permanent resident right now, if you hold a valid green card, if you are living in the United States, your status is not being taken away because of a 30-day deadline. I want you to hear that clearly because I know some of you are reading this with real fear in your hearts. Now, what is happening is serious and it does affect many people, but it's important to understand exactly who and how. On January 21st, 2026, the U.S. Department of State announced a pause on immigrant visa processing for nationals of 75 countries. This pause affects people who are applying for green cards from outside the United States through consular processing at embassies and consulates. It does not affect people who are already green card holders. It does not require anyone to leave the country. It does not take away status that has already been granted. What it does is temporarily stop the government from issuing new immigrant visas to people from certain countries while they review screening and vetting policies. The countries affected by this pause include places like Afghanistan, Albania, Algeria, Antigua and Barbuda, Armenia, Azerbaijan, Bahamas, Bangladesh, Barbados, Belarus, Belize, Bhutan, Bosnia and Herzegovina, Brazil, Burma, Cambodia, Cameroon, Cape Verde, Colombia, and many others. The full list includes 75 countries total. The stated reason for this pause is that the government wants to ensure that immigrants are financially self-sufficient and not likely to become a public charge, meaning reliant on public benefits. Officials have also cited national security concerns and the need to review information sharing policies with these countries. I know this sounds broad, and that can feel unsettling. When policies affect entire countries, it often raises questions about fairness, about discrimination, about what the real motivations are, and there is ongoing legal challenge to this policy. A lawsuit filed in federal court argues that this freeze violates the Administrative Procedure Act, the Immigration and Nationality Act, and constitutional equal protection principles. The lawsuit points out that most immigrant visa applicants are not even eligible for public benefits for years after arrival, and that the law has never been used before as a sweeping bar based on nationality. So if you are waiting for an immigrant visa to be processed at a U.S. embassy or consulate, and you are a national of one of the 75 affected countries, yes, this pause directly impacts you. Your case is on hold right now. There is no clear timeline for when processing will resume. That is frustrating. That is painful. And I know that for many families, this means separation continues, plans are delayed, and uncertainty grows. If this is your situation, I want you to know that you are not forgotten, you are not invisible, and there are organizations and legal advocates working to challenge this policy and push for clarity. However, if you are already in the United States and you are adjusting your status through USCIS, this pause does not apply to you. Adjustment of status cases, the ones filed with Form I-485 inside the United States, are still being processed. USCIS has not announced any freeze on adjustment of status applications for people from these countries. So if you filed your green card application while you're already here in the US, your case continues to move through the system. Processing times may still be slow because of backlogs and staffing, but the pause on consular processing abroad is a different process and does not stop your case. And if you are already a green card holder, if you already have lawful permanent resident status, this policy change does not take your green card away. You do not need to leave the country. You do not have a 30-day deadline. Your status remains valid. Now let me slow down here and explain something very important. I know that once fear enters the conversation, it's easy for people to start worrying about other ways they might lose their status. So let's talk clearly and calmly about how someone who already holds a green card can actually lose that status, because understanding the real rules helps you separate facts from rumors. Green card holders can lose their status in specific situations, and most of them involve choices or actions that are within your control. The most common way people lose permanent resident status is by abandoning it, and this usually happens when someone spends too much time outside the United States. The general rule is that if you stay outside the US for more than 1 year continuously, the government can assume you abandoned your residency. Even shorter absences, especially if they're longer than 180 days, can raise questions. When you return to the United States after a long absence, Customs and Border Protection officers may take you to secondary inspection and ask you questions about whether you intended to keep the U.S. as your permanent home. They may look at things like whether you filed U.S. tax returns, whether you maintained a home or job in the U.S., whether you have family ties here, and whether your actions show that you meant to come back. If the officer believes you abandoned your status, they can start removal proceedings or pressure you to sign a form called I-407, which is a voluntary abandonment of your green card. I want to be very clear about this. You do not have to sign that form. If you are questioned at the airport and you believe you did not abandon your status, you have the right to defend yourself in immigration court. Do not let anyone pressure you into giving up your green card on the spot if that is not what you want to do. If you know you need to stay outside the United States for an extended period, the smart thing to do is plan ahead. You can apply for a re-entry permit before you leave, which allows you to stay outside the U.S. for up to 2 years without losing your status. This shows that you intended your absence to be temporary and that you are maintaining your ties to the United States. Applying for a re-entry permit is not complicated, but it does require that you be physically present in the U.S. when you file the application and for biometrics. Once you have the permit, it protects your status while you're abroad for the approved time period. If you did not get a re-entry permit and you stayed outside the U.S. longer than expected, you may be able to apply for a returning resident visa, also called an SB1 visa, at a U.S. consulate. This is more difficult and requires you to prove that your extended absence was due to circumstances beyond your control and that you always intended to return. It's not guaranteed, and the process can be challenging, but it is an option if you find yourself in that situation. Another way green card holders can lose status is through certain criminal convictions. Not every crime will result in deportation, but there are specific categories of offenses that can make a green card holder deportable. These include aggravated felonies, crimes involving moral turpitude, drug offenses including marijuana in many cases, domestic violence, firearms violations, and certain fraud or theft crimes. If you are convicted of one of these offenses, immigration officials can start removal proceedings against you. This does not happen automatically or overnight. You have the right to appear in immigration court, to be represented by an attorney, and to present defenses or apply for relief from removal if you are eligible. Some people qualify for cancellation of removal, which allows certain long-term residents to keep their green cards even after a conviction if they meet strict requirements. The key thing to understand is that criminal issues and immigration status are deeply connected. If you are ever arrested or charged with a crime and you are a green card holder, it is extremely important to consult with both a criminal defense attorney and an immigration attorney before you accept any plea deal or conviction. Sometimes what seems like a minor charge can have serious immigration consequences, and an experienced attorney can help you navigate that. Conditional green card holders face a specific requirement that is very important to understand. If you received your green card through marriage to a U.S. citizen and you were married for less than 2 years when you got the green card, your status is conditional. That means your green card is only valid for 2 years. Within the 90 days before that 2-year mark, you must file Form I-751 to remove the conditions and make your green card permanent. If you do not file this form on time, your conditional status expires and you can be placed in removal proceedings. This is one of the most common mistakes that leads to people losing their green cards, and it is completely avoidable. If you have a conditional green card, mark your calendar, set reminders, and do not let that 90-day window pass. If your marriage ended in divorce or your spouse will not cooperate with filing the joint petition, you can still file for a waiver and remove the conditions on your own, but you need to do it within that time frame. Similarly, if you received a conditional green card through investment, you must file Form I-829 within the 90 days before your card expires. The same rules apply. Do not let that deadline pass. Green card holders can also face problems if they commit immigration fraud or if it is discovered that they obtained their green card through fraud or misrepresentation. If the government finds out that you lied on your application, hid important information, entered a fraudulent marriage for immigration purposes, or submitted fake documents, they can revoke your green card and start removal proceedings. These cases are serious, and they go through immigration court with evidence, testimony, and legal arguments. The standard is high because revoking someone's permanent residence is a significant action, but when fraud is proven, the consequences are real. Now let me say something important. All of these situations, abandonment, criminal convictions, conditional green card deadlines, fraud, these are specific, clear circumstances. They are not vague. They are not random. They are not things that happen to people who are following the rules, filing their taxes, maintaining their residence, staying out of trouble, and being honest. The overwhelming majority of green card holders never face any of these issues. If you are living in the United States, working, raising your family, traveling occasionally but always returning, paying your taxes, and following the law, your green card is not in danger. I want you to hear that clearly because fear can make us imagine worst-case scenarios even when they don't apply to us. Right now, in February 2026, there are also other immigration changes happening that are affecting different groups of people. For those who are waiting for green cards, processing times continue to be long in many categories. USCIS is still working through a significant backlog with millions of pending cases across the system. Some cases are moving faster than expected, especially in certain employment-based categories, while others, particularly family-based petitions in high-demand regions, are taking much longer than the posted timelines. The February 2026 Visa Bulletin shows modest forward movement in a few categories. For example, the EB3 category for skilled workers and professionals advanced by 3 months for applicants from most countries, Mexico, and the Philippines. Family-based categories saw limited movement, with some categories for Mexico advancing by a few months, while most others remained unchanged. For applicants from India and China in employment-based categories, the wait times continue to be extremely long, with little to no forward movement in recent months. These backlogs are frustrating, and I know that waiting for years to reunite with family or to finalize your status feels unfair and exhausting. If you are currently waiting for your priority date to become current so you can file your adjustment of status application, keep checking the Visa Bulletin every month. USCIS has announced that for February 2026, applicants should use the dates for filing chart for both family-sponsored and employment-based categories. This means that if your priority date is earlier than the date listed in the dates for filing chart for your category and country, you can file your Form I-485 even if your date has not yet reached the final action date. This does not mean you will get approved immediately, but it allows you to get your application into the system, apply for a work permit and travel document while you wait, and start the process. Priority dates can move forward, stay the same, or even move backward from month to month, depending on how many visa numbers are available and how many people are applying. This is called retrogression, and it can be discouraging when it happens, but it is part of how the system manages the annual limits on green cards. In this episode, we're going to talk about the truth behind green card security in 2026, what's happening right now with immigrant visa processing, how green card holders can lose their status, and what all of this really means for people living in the United States, applying from abroad, and planning their futures. And as always, this is not legal advice. I'm not a government official or an attorney. I'm simply here to help you understand information in a simple, calm, and supportive way so you don't feel lost or overwhelmed. Or for people on temporary visas who are hoping to adjust status or who are worried about their ability to stay in the US, there are also changes happening with visa policies and enforcement. The travel ban that took effect on January 1, 2026, applies to certain nationals who are outside the United States and do not have a valid visa. If you are already in the United States with a valid visa, the travel ban does not require you to leave. If you are a green card holder, the travel ban does not affect your ability to enter or remain in the United States, regardless of your country of citizenship or birth. However, if you are planning to travel outside the US and you are from one of the affected countries, you should be very cautious. Talk to an immigration attorney before you leave, because even though the travel ban has exemptions, there can be confusion at ports of entry, and you may face additional screening or questioning when you try to return. Students on F1 visas should continue following all the rules of their status. Maintain full-time enrollment, stay in touch with your school's international student office, and do not work without proper authorization. If you have optional practical training or are applying for a work permit based on your student status, processing times for those applications have been variable. Some applicants receive approval quickly, while others experience delays. The best thing you can do is apply early, respond promptly to any requests for evidence, and keep copies of everything you submit. If you are on OPT and your work authorization is about to expire, Make sure you understand the gap rules and whether you are allowed to continue working while your extension is pending. Workers on H-1B, L-1, and other employment-based visas should also be aware that the current environment involves increased scrutiny in some cases. USCIS has been conducting more site visits and requesting more evidence to verify that workers are performing the jobs described in their petitions. If you receive a request for evidence, do not ignore it. Work with your employer and your immigration attorney to provide complete, accurate documentation within the deadline. Premium processing is still available for many employment-based petitions, and the fee is increasing on March 1, 2026, as part of a required inflation adjustment. The new fee will be higher, so if you have a case that you know will need premium processing soon, filing before March 1 might save you money. For families who are going through the marriage-based green card process, there have been reports in early February 2026 of immigration officials arresting people during green card interviews with their U.S. citizen spouses. This tactic is being challenged in court, and a judge in Maryland has issued an order blocking such arrests in that jurisdiction, but the Trump administration is appealing that decision. If you have an upcoming marriage-based green card interview and you have any past immigration violations, unlawful presence, or removal orders, it is extremely important that you consult with an immigration attorney before your interview. Understand your risks, know what questions you may be asked, and have a plan. Most marriage-based interviews proceed normally, with routine questions about your relationship, your life together, and your documents. Officers are looking to confirm that your marriage is genuine and that you meet the eligibility requirements. Bring all requested documents, answer honestly, stay calm, and if you don't remember something exactly, it's better to say you're not sure than to guess. If USCIS requests additional evidence after your interview, that is common and does not automatically mean denial. It often just means they need more documentation to verify something before they can approve your case. Travel is another area where green card holders sometimes run into problems, and I want to give you some practical guidance. Before you travel internationally, make sure your green card is not expired. Technically, an expired green card does not mean you lose your status as long as you are a permanent resident, but airlines may not let you board a flight back to the U.S. without a valid green card, and you may face delays and questioning at the border. If your green card is expiring soon, file Form I-90 to renew it well in advance. Processing times for green card renewals can take several months, but you will receive an extension notice that you can use along with your expired card to prove your status while you wait for the new card. If you are traveling with an expired green card and an extension notice, carry both documents with you and allow extra time at the airport in case there are questions. If you are a green card holder who travels frequently for work or family reasons, keep records of your trips. Note your entry and exit dates, keep copies of your boarding passes or passport stamps, and be prepared to show that you are maintaining your residence in the United States. If you are ever questioned at the border about how much time you spend outside the U.S., you want to be able to demonstrate clearly that your home is here, that you file U.S. taxes, that you have a job or family ties here, and that your trips abroad are temporary. Being organized and honest makes those conversations much easier. Another question I receive often is about dual citizenship and whether holding a passport from another country puts your green card at risk. For most people, the answer is no. The United States generally allows dual citizenship, and many green card holders maintain citizenship in their home country while also holding permanent residence in the U.S. You can travel on your foreign passport, visit family, renew that passport, and even vote in elections in your home country, in most cases, without affecting your U.S. status. What can create problems is if you take actions that show you intend to permanently reside in another country, or if you take a formal government position in another country that conflicts with U.S. interests. Simply having two passports, traveling back and forth, and maintaining cultural ties does not endanger your green card. If you ever have specific concerns about whether a particular action might be seen as abandoning your U.S. residence, consult with an immigration attorney who can assess your individual situation. I also want to address the emotional side of all of this, because immigration is not just about paperwork and policies. It's about your life. It's about your family. It's about the future you are trying to build. When you hear news that sounds threatening, when processing times drag on for months or years, when you see headlines that use words like ban and deportation and status lost, it is completely normal to feel scared. It is normal to feel frustrated. It is normal to wonder if all your effort and patience will actually lead somewhere. And if you are separated from loved ones, if you are waiting for a visa that is now on indefinite hold, if you are watching your plans fall apart because of policy changes you cannot control, I know that hurts. I know it feels personal even when it's not about you as an individual. Immigration systems affect real human beings, and sometimes those systems move slowly, change unexpectedly, and create hardship. What I can tell you is that millions of people have walked this road before you. Many have faced delays longer than they imagined. Many have dealt with policy changes, backlogs, uncertainty, and fear, and many eventually reached the outcome they were hoping for. Staying informed does not remove all the stress, but it does help you feel more grounded. Knowing what is actually happening versus what is rumor or exaggeration allows you to make better decisions. Understanding your rights, your responsibilities, and your options gives you a sense of control even when the system feels chaotic. If you are a green card holder, the most important things you can do are simple. Maintain your residence in the United States. File your taxes every year. Keep your green card valid and renew it on time. If you have a conditional green card, do not miss the deadline to remove the conditions. If you travel, keep your trips reasonable in length and always return. Stay out of legal trouble, and if you ever face a criminal charge, consult with both a criminal attorney and an immigration attorney before taking any action. Follow the rules of your status, respond promptly to any government requests, and keep copies of all your immigration documents in a safe place. If you are waiting for a green card and your case is affected by the current pause on immigrant visa processing, stay in touch with the National Visa Center or the embassy handling your case. Monitor updates from the State Department and from immigration advocacy organizations that are challenging the policy. Consider whether you have any options to adjust your status from within the United States if you are already here on a different visa. And if you are outside the US and waiting, I know this is the hardest advice, but try to be patient while also exploring every legal option available to you. Consult with an immigration attorney who can review your specific situation and tell you whether there are any alternatives or waivers that might apply. For everyone navigating immigration right now, whether you are applying, waiting, adjusting, renewing, or simply living your life as a permanent resident, remember that awareness is not the same as panic. Yes, policies are changing. Yes, there is uncertainty. Yes, some people are being affected by delays and restrictions that are frustrating and painful. But for most green card holders, your status is secure as long as you are following the rules, maintaining your residence, and staying informed. You do not need to live in constant fear of losing something you have already earned. What you do need is accurate information, and that is what I try to provide. As we bring everything together, I want to return to the main truth behind today's topic. Current green card holders in the United States are not facing a 30-day deadline to lose their status. That is not happening. What is happening is a pause on immigrant visa processing for people applying from 75 countries through consular processing abroad. This pause is being legally challenged, it has no announced end date, and it is creating real hardship for families waiting to reunite and for people hoping to start their lives in the United States. If that is your situation, I am truly sorry. You deserve clarity, you deserve fairness, and you deserve to have your case processed. At the same time, if you already hold a green card, your status is protected as long as you meet your responsibilities. Abandonment, criminal convictions, missing deadlines for conditional status, and fraud are the main ways people lose permanent residence, and all of those are specific situations that most people will never face. Immigration journeys are long, detailed, and sometimes confusing. Processing times shift, rules sometimes change, interviews get delayed, notices arrive when you least expect them. And through all of that, you may feel worried, tired, or uncertain. I want you to hear this clearly. Confusion is normal. Questions are normal. Feeling impatient, frustrated, or overwhelmed is normal. What matters most is staying informed, staying truthful, and staying patient with yourself. Whenever we talk about immigration systems, it can be easy to think of everything as just paperwork and regulations. But behind every case number, there is a real human being. There is a parent trying to reunite with a child. There is a worker contributing skills and building a future. There is a spouse waiting to live under the same roof again. There is a student hoping to stay and build a career. And there are green card holders, some who have held that status for decades, who sometimes feel unsure about what new policies might mean for them. If you are one of them, remember that learning is power. Understanding how things work gives you clarity, and clarity helps you make calm, thoughtful decisions. Throughout today's update, I've shared information, not legal advice and not predictions, because immigration journeys are personal and unique. If you ever face a complicated situation, getting professional help can bring reassurance. And if everything is going smoothly, staying informed helps you remain confident and prepared. Whether you are at the beginning of your immigration path or you are already living as a permanent resident, your story matters, and you deserve truthful, respectful information. So here's the gentle takeaway I hope you leave with today. Green card status is strong, it is protected, it is valuable, and while there are specific ways it can be lost, those situations are clear, they are documented, and they usually involve choices or circumstances that are understandable and often avoidable. At the same time, the immigration system in February 2026 is experiencing real changes that are affecting new applicants, creating uncertainty and causing delays. Visa processing is paused for many countries. Backlogs are long. Policies are being challenged in court. And for people caught in the middle of those changes, the waiting and the worry are exhausting. If today's update helped you feel more informed or more calm, I'm truly glad. Immigration journeys can be stressful, but staying aware step by step helps you stay prepared. If you'd like to receive more daily updates about U.S. immigration, visas, green cards, citizenship, and travel, you're welcome to stay connected here. And if you have a question or experience to share, feel free to leave it in the comments. Your story may comfort or guide someone else who is watching and feeling the same worries you once felt. Thank you for spending this time with me today. I appreciate your trust and your presence. Take care. Stay hopeful.